The public's right to be informed about the actions and activities of those who represent them is essential to maintaining an open and transparent government. The public has the right to know what goes on in public meetings and what is contained in the government's public records. Open government is mandated by District of Columbia law so that the public is aware not only of the outcome of the government's decisions, but also the process by which those decisions are made. Hello, I am Niquelle Allen, Director of Open Government for the District of Columbia. I am pleased to present this training program on the District of Columbia Open Meetings Act. The Office of Open Government is a part of the Board of Ethics and Government Accountability that is responsible for ensuring that the District of Columbia's operations are open and transparent. We are responsible for enforcing the Open Meetings Act. I have found that most often when government officials do not comply with the Open Meetings Act, it is generally because those officials do not understand or are unaware of what the law requires of them. This training program aims to increase the understanding and awareness of the open meetings laws and how to apply those laws to public bodies and public officials. By the end of this training program, you will have the tools you need to conduct meetings that comply with the Open Meetings Act. Thank you for your participation and attention, and for your continued dedication to openness and transparency in the District of Columbia government. This training program will outline the requirements of the Open Meetings Act and the basics of what the law requires you to do as a member of a board, commission, or other public body to remain in compliance with the law. This training session will begin with the introduction and overview of the Open Meetings Act. The Open Meetings Act is codified at DC Official Code Sections 2-571 through 2-580. The Open Meetings Regulations, 3 DCMR Chapter 104. The Open Meetings Act requirements remind us that public officials' actions and activities must be subject to public scrutiny. The law requires that all meetings of public bodies must be open to the public, except where the law permits a closed meeting. The public must be given advance notice of the date, time, place, and agenda of the meeting. Records of the meeting must be maintained. The Open Meetings Act provides for civil enforcement actions for violations of the Open Meetings Act. The District of Columbia Open Meetings Act was first adopted on March 31st, 2011. The act was adopted to provide the public knowledge of and access to the meetings of boards, commissions, and other similar bodies to increase government transparency and enhance public confidence in the government. President James Madison stated the reasoning for open government precisely. He said, "A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both. Knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power knowledge gives. To that end, in the District of Columbia, all persons are entitled to full and complete information regarding the affairs of government and the actions of those who represent them." This training video will cover the following topics. First, the requirement of a public body to hold open meetings. Second, what is a meeting that is subject to the Open Meetings Act? Third, notice of the meeting. Fourth, closed meetings. Fifth, record keeping. Sixth, public participation and comment. And last, penalties and remedies for violations. Public bodies are required to hold open meetings. Under the Open Meetings Act, all of a public body's meetings must be open to the public unless the law allows for a closed meeting. The Open Meetings Act must be construed broadly to maximize the public's access to meetings. Exceptions should be construed narrowly to permit closed meetings only as authorized. A meeting is deemed open to the public if 1. The public is permitted to be physically present. 2. The news media is permitted to be physically present. Or 3. The meeting is televised. The first topic I will discuss is what is a meeting that is subject to the Open Meetings Act. When meetings come to mind, this is likely what you think of.
This is an additional meeting of the Committee of the Whole. I'm Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole.
That meeting is the most common public meeting that people in the District of Columbia are familiar with. But gatherings and meetings subject to the Act may be more or less formal than a District of Columbia Council public meeting. You just saw the D.C. Council opening their public meeting. This training will present several meeting scenarios. The goal is that by having you view these scenarios, you will have the tools for dealing with some of the issues you may face in your public meeting. We will also go through the steps you should be following when conducting your meeting and the meeting requirements. So what constitutes a meeting? The Open Meetings Act defines a meeting as a gathering of a quorum of the members of a public body where the members consider, conduct, or advise on public business. Meetings can be formal or informal. They can be hearings or roundtables. In a meeting, members may be gathering information, taking testimony, discussing, deliberating, recommending, or voting. The meeting may be in person or held electronically. Let's break this definition down further and look at the term public body more closely so you will know which entities are subject to the Open Meetings Act. The Open Meetings Act applies to public bodies. This includes all boards and commissions defined under D.C. Official Code Section 1-523.01. It also includes the D.C. State Board of Education, the D.C. Public Charter School Board, D.C. Public Charter School Boards of Trustees, local school advisory teams, the D.C. Water and Sewer Authority, the Alcohol Beverage Control Board, and any other entity that is created by and exercises authority delegated by the D.C. government. However, D.C. courts, which are regulated under federal law, the mayor's cabinet, and advisory neighborhood commissioners are not subject to the Open Meetings Act. The next term is quorum. So what is a quorum? The term generally means the majority of a public body. The Office of Open Government interprets that to mean half of the public body's members plus one. Let's say, for example, there are 8 members of the Public Charter School Board. 5 of those members must be present to constitute a quorum. A quorum of members must be present for a public body to have a meeting and consider, conduct, and advise on government business and take official action. Trying to determine when a gathering is considered a public meeting is pretty straightforward. However, you may face some challenges. The following scenarios have a 5-member public body. The first step in determining whether a gathering is a public meeting subject to the Open Meetings Act is establishing a quorum.
I would like to call this meeting to order and acknowledge all 5 members of the board are present and we have a quorum.
In this scenario, the members are properly conducting a meeting because all of the members are present and they have properly established a quorum. Let's look at another example of a quorum.
Hey, Michelle, what do you think about the new tax proposal?
I think it's a great idea.
Well, I agree with Board Member Pratt. We need some time to revise it.
This is an example of a meeting subject to the Open Meetings Act. Even though the public body has not called a meeting, this gathering became a meeting because the members were gathered with a quorum present and were discussing public business. You should avoid discussing public business with your fellow public body members if you happen to see them by chance, to avoid violating the Open Meetings Act. Members must make sure they do not drift into an illegal meeting when at a social gathering or in a chance meeting at a public location, such as at the grocery store or in a government building. You may remain friends and socialize with other public body members, just refrain from discussing public business. If you are with a fellow public body member and they begin to discuss public business, you should request they hold the information for a later appropriate time. Anytime you encounter discussion of public business outside of the course of an open meeting, you should develop the habit of asking yourself whether the discussion would violate the Open Meetings Act. If you are unsure, err on the side of caution and refrain from engaging in the discussion until the matter can be discussed in a formal meeting. Let's look at what happens when you gather for a meeting and there is not a quorum present.
We only have 2 board members present, myself, Chairman Kwame Jones, and board member Michelle Yao. Since we do not have a sufficient number of members present to conduct a meeting under the Open Meetings Act, this meeting is adjourned.
In this scenario, the chairman's action was appropriate. He could not properly conduct a meeting because there was not a quorum of members present. The only proper action to take is to adjourn. So to reiterate, a meeting is subject to the Open Meetings Act when a quorum of a public body are gathered to discuss government business or take official action. Next, we will examine the requirements for permitting the public to attend or view a meeting. The second topic is how will the public know about the meeting? Well, the public is entitled to receive proper advance notice of a meeting in order to comply with the Open Meetings Act. In general, the notice must provide the public with an awareness of what will be discussed at the meeting. The Open Meetings Act requires a public body to provide notice when meetings are scheduled and change. The notice must include the meeting date, location, time, place, and draft agenda. If the meeting or any portion of the meeting will be closed, the notice must include a statement of an intent to close and cite the statutory reason for the closed meeting. The notice should include a statement at the end of the agenda that says, "This meeting is governed by the Open Meetings Act." Please address any questions or complaint arising under this meeting to the Office of Open Government at opengovoffice@dc.gov. Notice must be posted in the public body's office or a location that is readily accessible to the public, like a library. Internet posting is also required. You must post your timely meeting notice on your public body's website and on the central meeting calendar located at open-dc.gov. Meeting notice must also be posted in the DC Register. Except for emergency meetings, notice must be provided to the public no less than 48 hours or 2 business days, whichever is greater, before the meeting. A public body should establish an annual calendar of its meetings and update it throughout the year. The calendar should be published in the DC Register and on the Internet. Public charter school boards of trustees or local school advisory teams are not required to publish notice of meetings in the DC Register. Now let's talk about record keeping. The Open Meetings Act requires that public bodies record every action taken in a public meeting. The meeting recording and meeting minutes are public records that must be available to the public. The Act requires that a public body must record all of its meetings by electronic means, whether those meetings are open or closed. If recording is not feasible, the public body must take detailed minutes of the meeting that have to be preserved for 5 years. The public body must also have a retention schedule that has been approved by the District of Columbia archivist. That schedule will dictate how a public body may dispose of records. Recordings and other records of public meetings must be maintained for a minimum of 5 years. You should check with your record retention manager or the DC archivist if you have questions about record retention. Copies of meeting minutes must be made available to the public no later than 3 business days after the meeting. For public charter school boards of trustees, copies of the meeting minutes must be made available to the public no later than 30 days after the meeting. Copies of meeting recordings and transcripts must be made available to the public no later than 7 business days after the meeting. Record keeping is vital to the success of your public body and is an essential component of government accountability. There are certain times when a public body may close the meeting to the public. A public body cannot discuss its public business in a closed meeting unless there is a specific provision in the Open Meetings Act that justifies the closure. Only members of a public body have the right to attend a closed meeting, although a public body's attorney must be present when closing the meeting using attorney-client privilege. A public body also has the discretion to include officers and employees in a closed meeting if their participation is necessary to the example under consideration. Now let's examine our fictional public body entering into a closed session of a public meeting.
The next agenda item is a closed session to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and public body pursuant to DC Official Code Section 2-575B4A. I will now entertain a motion to move into executive session.
I move that the board enter into executive session pursuant to DC Official Code Section 2575B4A.
I second Ms. Yao's motion.
All in favor of the motion, say aye.
Aye.
Any opposition? Hearing no objection, the motion passes. It is 10:30 a.m. and we are now entering into executive session.
Now that you have seen a public body enter into a closed session, let's talk about it in detail. Closed meetings must be specifically authorized by the Open Meetings Act, and the public must have received prior notice of the closed meeting. When a public body wishes to enter into a closed meeting, the public body must first assemble and properly convene an open meeting. This must be done even if the public body plans to immediately proceed into a closed meeting. The presiding officer must announce in a public meeting that a closed meeting will be held and identify the statutory provision that authorizes the closed meeting. The presiding officer must entertain a motion to enter into the closed meeting, and the board members must vote and agree to enter into the closed meeting. At that point, the closed meeting may commence. The public body may only discuss matters properly noticed and authorized by statute. How does our fictional public body deal with this issue? Let's see.
We need to discuss the termination of the school principal. I don't agree with it.
That matter is not on the agenda, and the public does not have notice, so we cannot talk about it today.
Remember that unless the matter was properly noticed, it cannot be discussed in the closed session. The proper action to take is to cease discussion of the matter and take it up in a properly noticed meeting. Once the public body has concluded the closed portion of this meeting, they must reconvene in a public meeting to conclude the meeting. If there was a matter decided in the closed portion of the meeting, that should be reported in an open meeting. The public body should do so prior to ending the meeting. It is key to remember that a public body may only meet in closed sessions for reasons authorized by the Act. These reasons are construed narrowly. The Open Meetings Act provides that a meeting may be closed for the following reasons. 1, a law or court order requires that a particular matter or proceeding not be public. 2, to discuss, establish, or instruct the public body's staff or negotiating agents concerning the position to be taken in negotiating the price and other material terms of a contract, including an employment contract, if an open meeting would adversely affect the bargaining position or negotiating strategy of the public body. 3, to discuss, establish, or instruct the public body's staff or negotiating agents concerning the position to be taken in negotiating incentives relating to the location or expansion of industries or other businesses or business activities in the district. 4, to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and a public body, or to approve settlement agreements, provided that, upon request, the public body may decide to waive the privilege. 5, planning, discussing, or conducting specific collective bargaining negotiations. 6, preparation, administration, or grading of scholastic, licensing, or qualifying examinations. 7, to prevent premature disclosure of an honorary degree, scholarship, prize, or similar award. 8, to discuss and take action regarding specific methods and procedures to protect the public from existing or potential terrorist activity or substantial dangers to public health and safety, and to receive briefings by staff members, legal counsel, law enforcement officials, or emergency service officials concerning these methods and procedures. 9, to discuss disciplinary matters. 10, to discuss the appointment, employment, assignment, promotion, performance, evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials, or of public charter school personnel where the public body is the board of trustees of a public charter school. 11, to discuss trade secrets and commercial or financial information obtained from outside the government or public body, to the extent that the disclosure would result in substantial harm to the competitive position of the person from whom the information was obtained. 12, to train and develop members of a public body and staff. 13, to deliberate upon a decision in an adjudication action or proceeding by a public body exercising quasi-judicial functions. 14, to plan, discuss, or hear reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations if disclosure to the public would harm the investigation. 15, to discuss matters involving personally identifiable information of students. And 16A, when the public body is the board of trustees for a public charter school, to meet with the staff of an eligible chartering authority for the purpose of being evaluated by the eligible chartering authority. The Open Meetings Act permits public bodies to hold remote or electronic meetings. Under the Act, a public body may hold a meeting by video conference, teleconference, or other electronic means like social media, but there are some requirements. First, the public body must make reasonable arrangements to accommodate the public's right to attend. There needs to be a telephone number or meeting link provided for the public, for example. The meeting has to be recorded, and all votes must be taken by roll call. All of the Open Meetings Act requirements and rules and procedures apply to electronic meetings. You should note that email meetings are not considered electronic meetings under the Open Meetings Act. The Open Meetings Act provides the public with the opportunity to observe the public meeting. The Act does not provide a right to participate in the meeting. Generally, whether or not to permit members of the public to comment during the meeting is in the public body's discretion. However, some public bodies enabling legislation or bylaws may have specific requirements about public comment. Public body members must make sure to read and understand those requirements and craft those public meetings to carry out those requirements regarding public comments. Public bodies may provide opportunities for public comments within their own discretion. Now let's discuss special circumstances that may occur. Emergency meetings and cancellations. What is an emergency meeting? The Act defines it as a meeting to discuss an urgent matter. The public body's presiding officer must clearly state the nature of the emergency at the beginning of the emergency meeting. The presiding officer must also state how notice of the meeting was given to the public at the beginning of the emergency meeting. Notice must be given to the public at the same time it is given to members of the public body. The emergency meeting must be called in good faith and not be used as an attempt to circumvent the Open Meetings Act requirements. Meeting cancellations. A public body may cancel a meeting if necessary. A meeting cancellation is a change in schedule. In most instances, a meeting cancellation requires as much notice to the public as possible, but not less than 48 hours or 2 business days, whichever is greater, before the meeting was to occur. To establish a record, the meeting notice to the public must be published according to the requirements of the Act, but state canceled. As public body members, you must always remember to take the steps necessary to ensure that members of the public have access to the public meeting and meeting records, even when special circumstances arise. The Office of Open Government has the authority to enforce the Open Meetings Act by bringing a lawsuit in D.C. Superior Court for injunctive or declaratory relief. We may bring the lawsuit before or after the meeting in question occurs. If the court finds that the public body held an illegal closed meeting, it may, 1, enjoin the public body from closing the meeting, 2, order that future meetings be open to the public, or 3, order that a meeting record be made public. If the court finds that a resolution, rule, act, regulation, or other official action was taken, made, or enacted in violation of the Open Meetings Act, the court may order an appropriate remedy, including requiring additional forms of notice, postponing a meeting, or declaring that action taken at a meeting to be void. If the court finds that a member of a public body engages in a pattern or practice of willfully participating in one or more closed meetings in violation of the Open Meetings Act, the court may impose a civil fine of not more than $250 for each violation. A public body may also seek an advisory opinion from the Office of Open Government regarding the interpretation of the provisions of the Open Meetings Act. This training program has covered numerous topics and issues that you may have to confront in your service to the District of Columbia as a member of a public body. In the execution of your duties, you may find that you have more questions about the Open Meetings Act. If you have any questions, please call the Office of Open Government at 202-481-3411 or send us an email at opengovoffice@dc.gov. There are also numerous resources to assist you on our website, open-dc.gov. There you will find the Open Meetings Act, regulations, and numerous advisory opinions on open meetings. If you would like to schedule additional trainings, do not hesitate to contact us. Thank you for your time and attention. For the Office of Open Government, I am Director Niquelle Allen.